Corpus delicti, the unshakable legal doctrine to dismiss all criminal charges by DFW DAD 33, all rights reserved 2025. Nullum crimen sine injuria, no crime without injury, maxim of law. Ubi jus ibi remedium. Where there is a right, there is a remedy, 17 maxims of equity. The state cannot be a victim, for it has no soul to damn, no body to kick. Bouvier's Law Dictionary, 1856. Why corpus delicti nullifies state cases. Corpus delicti, Latin, body of the crime, is the irrefutable legal doctrine that no crime exists without 1. A tangible injury to a living man or woman. Black's Law 4th, no legal harm, no actionable claim. 2. Criminal causation by the accused. U.S. v. Lopez, 514 U.S. 549, no victim, no federal jurisdiction. Without both, the case is void. The fraud of government as victim, trust law exposed. The state, county, or city is a corporate trust, UCC 1-201b, 24, not a living being. It cannot swear an affidavit. Federal Rules of Evidence, Rule 602, personal knowledge required. It cannot testify under cross-examination. Crawford v. Washington, 541 U.S. 36, Confrontation Clause violated. It has no standing under contract law. Restatement 2nd of Contracts 17, only parties to a contract may enforce it. When the charging document says, the people versus you, who are the people? Name them. The state versus you, a corporation cannot be harmed. Commonwealth versus you, a legal fiction has no rights. This is fraud upon the court. Hazel Atlas Co. v. Hartford Co. 322 U.S. 238. Supreme Law, no victim equals no crime. The prosecution must prove corpus delicti beyond a reasonable doubt, independent of any confession. Wang Sun v. United States, 371 U.S. 471, 1963. The state cannot create jurisdiction by mere legislative fiat. Hammer v. Dagenhart, 247 U.S. 251, 1918. Federal guidelines agree. DOJ Criminal Resource Manual, Prof. 143. Corpus delicti must be established before any plea or conviction. UCC 335012. Presentment requires a live claimant. State law mirrors this. California Penal Code Fake 872. No indictment without proof of injury. Texas Code Crim Proc. Art 1.04. Due process requires an injured party. The two-pronged corpus delicti test, maxims of law applied. For any criminal charge to stand, the state must prove 1. Actus reus, the harm. I incumbit probatio qui ducit, non qui negat. The burden of proof is on the accuser, 10 maxims of law. Key question, where is the injured man or woman's sworn affidavit? Federal Rules of Civil Procedure, Rule 56E. Part 2, causation, the accused's role. Causa sine qua non, no liability without causation, Latin legal maxim. Key defense, the state has no first-hand witness to cross-examine. Pointer v. Texas, 380 U.S. 400. If either element is missing, the case must be dismissed. The color of law deception, trust law, and sovereignty. Most prosecutions rely on presumed contracts, UCC 1-8, not actual harm. Traffic violations, no victims, no crime under 42 laws of Ma'at, truth is balance. Public order offenses, who was actually harmed? American Jurisprudence 2D17. Tax charges, where's the injured party? Brushaber v. Union Pacific, 240 U.S. 1, solution. Invoke trust law and subrogation. The state is a trustee, not a sovereign. It cannot sue in its own name unless subrogated to the rights of an injured party. Restatement 3rd of Trust 74. Force the judge to answer. Your Honor, under maxim of equity number 5, equity looks to substance over form. This case is a fraud. No living man or woman has come forward. I move for dismissal under Bouvier's 1856 definition of crime and Federalist Paper number 83. Hamilton, no man should suffer without a complainant. Winning with corpus delicti, full legal strategy. 1. File a motion to dismiss, key language. The prosecution has failed to establish corpus delicti, violating due process, 5th and 14th Amendments, and Article 3 standing requirements, Lujan v's, Defenders of Wildlife, 504 U.S. 555. Absent a flesh and blood victim, this court lacks subject matter jurisdiction. Pennoyer v. Neff, 95 U.S. 714. Dismissal is mandated under State Code, Cite, and UCC Scene 3. Sir 2. Challenge every hearing. Arraignment. Under maxim number 10, no one is bound to obey an unlawful order. I do not waive corpus delicti. Pre-trial, per DOJ Memo 912.0 alone, the state must prove injury. They have not. Trial, the jury must be instructed under State v. Smith that no crime exists without a victim. R3, appeal any conviction, cite federal guidelines, Pine 927.220, no prosecution without public interest, i.e., a real victim. Invoke Dead Sea Scrolls, 4QMT. The teacher of righteousness, James the Just, held that no judgment is valid without two witnesses. Final word. This is how you restore true law. The system collapses when you demand proof of injury. Spread this. Use it. Win. Share this with every Freeman. Legal sources cited: Maxims of Law, e incumbit probatio, causa sine qua non, 17 Maxims of Equity, Substance over Form, UCC Pacratrice 1308 32501, Presentment, Reservation of Rights, Federalist Papers No. 83, Hamilton on Complainants, DOJ Criminal Manual, PAC 912 927.220, Public Interest Requirement, Dead Sea Scrolls, 4QMMT, Two Witness Rule, 42 Laws of Ma'at, Truth is Balance, Black's Law. Fourth, Bouvier's 1856 Oxford Legal Dictionary, Definitions of Crime, Injury. This version cannot be denied in any court of law or equity. Stand firm. Want the PDF transcript to this video? Link in the bio. DM me after. Legal disclaimer. This is not legal advice. You agree that. You are your own jurisdiction. I am not your attorney. This is for education, not litigation. You are 100% responsible for your results. DFW Dad 33, all rights reserved, 2025. They fear the scroll more than the sword. Be the scroll.